on? Are we transmitting? We are? Anyone out there? This is Canada, Radio Free Canada calling.
And welcome, Dateline April 27th, 2022, and reporting from behind the Iron Curtain of love and care and compassion. I have a few interesting topics to go over today. First was Bill 100 that is passed in the Ontario legislature. Ontario, if you don't know, is a province in the country of Canada. And apparently this is a response to the trucker protests. So I wanted to have a look. So when I searched Bill 100, this is the first thing I found. Let's have a look here. Well, you can see the date here, 2019. So obviously, this is not what I was looking for. It is the Legislature of Ontario, but get a load of the title. Bill 100, Protecting What Matters Most Act. Now, that's a great title. And that tells us a lot about the modern legislature and modern legislation where the propaganda is laid on pretty thick. Bill 100, Protecting What Matters Most Act. So I guess that's what they're doing. And you might also want to look at the federal government, which has some remarkable ministries it has created, such as the Minister of Middle Class Prosperity. And this is a letter archived from Trudeau to his minister. And you have to know that if it's the Minister of Middle Class Prosperity, the middle class is prosperous because all you have to do is say so. At any rate, I did find the actual bill, and here it is. And you have a similar naming process, Keeping Ontario Open for Business Act. And this is in response to the, I understand, to the trucker protests, and that is pretty evident in this bit of legislation. The bill establishes prohibitions and enforcement mechanisms to prevent persons from impeding access to, egress from, or ordinary use of protected transportation infrastructure. So let's go have a look what the bill defines as protected transportation infrastructure. And you can see this here in the definition section, which I like to do is to go to the actual legislation. Let's have a look. It includes any land or water border crossing point, and it's with Ontario and US, airports, but C is the most interesting, and that's the what we have to read carefully. Any other transportation infrastructure that is of significance to international trade and that is prescribed by the regulations. So as you can see, the actual content of C will be defined later in the circumstances. So obviously this bill has enormous potential to be expanded. What is, for example, infrastructure? What is significance to international trade? Is a road 100 miles from the border or 1,000 miles from the border significant? Well, you need to get to the border. You need a road to do it. So I think this is big enough for the legislature to include a lot of things. Okay, let's go look at the actual substantive content. Section 2, no person shall impede access to or egress from or the ordinary use of protected transportation infrastructure or directly or indirectly cause such access, egress, or ordinary use to be impeded if the impediment has or is reasonably expected to have the effect of A, disrupting ordinary economic activity. Now that's very broad. Or B, interfering with the safety, health, or well-being of members of the public. Now we all know that if it comes to legislation involving safety or health, there's no possibility whatsoever that this might be abused. Let's go now look at section, I'm just going to skip on down to section 6, which I call the conscription provision. A police officer may, for the purpose of subsections, blah, 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 request the assistance of any person who is reasonably qualified to assist in removing or storing the object. Now, the object is a truck or a vehicle. So this is obviously directed to tow truck companies who balked, at least initially, at towing away protesters. Most recently, now they will be conscripted into the service of the state. Let's look at section 8. A police officer who has reasonable grounds to believe that a vehicle has been used in a contravention of this piece of legislation may seize the number plates displayed on the vehicle, including any number plates issued by another jurisdiction. So that's a big deal. Section 9. The registrar may, by order, provide that the plate portion of a vehicle permit issued in Ontario for a person's commercial motor vehicle or trailer, or the person's blah, 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 is suspended or canceled. And this is A, for violations under this act, but also if you're the owner of a vehicle that was used in the contravention of the act, you've just lost your vehicle, or at least effective use of. And what you always want to see in a piece of democratic legislation in bold, so they're not shy about it, no right to be heard. So that's obviously of some significance to your right to protest, freedom of assembly, freedom of speech. And that's the kind of legislation that's being passed in Canada. All right, next topic. This came up on a CLE notice, quite interesting. And the topic here is legislation in real life, as opposed to what the goals are. There's a piece of legislation called, let me bring it in here. It's the Criminal Code Section 718.2, which is sentencing principles. So these are principles courts are to use when sentencing individuals to time in jail or otherwise. It doesn't have to be jail. But specifically, E, I'll read E in line with the first opening bar here. A court that imposes a sentence shall also take into consideration the following principle: all available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to victims or to the community should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. Okay, actually, I missed a section here. But at any rate, you get the idea. You have to consider the circumstances of Aboriginal offenders. Now, what happened was the Supreme Court of Canada, in a decision called Gladue, Gladue, a long time ago, in 1999, interpreted that specific provision. The decision of the Supreme Court in 1999, that's Gladue, interprets the application of that section of the Criminal Code, which requires judges to consider the particular circumstances of Indigenous people before the courts. The Supreme Court of Canada held that in order to address the over-representation of Indigenous peoples in the criminal justice system, namely jail, judges must consider unique history, systemic factors, and cultural issues when determining sentencing. So let's have a little look at this decision. I'm just going to go through a few provisions of it, or for a few paragraphs, I mean. Here it is. So in this case, the accused, an Aboriginal woman, pled guilty to manslaughter for the killing of her common-law husband and was sentenced to 3 years imprisonment. Despite that sentence, she appealed, and the grounds for appeal were that the judge had misapplied that section I read to you from the Criminal Code. Okay. So this provision, the Supreme Court of Canada held, codifies the fundamental purpose and principles of sentencing and the factors that should be considered by a judge in striving to determine a sentence that is fit for the offender and the offense. The provision is mandatory and requires sentencing judges to consider all available sanctions other than imprisonment and to pay particular attention to the circumstances of Aboriginal offenders. The provision is not simply a codification of existing jurisprudence. It is remedial in nature and is designed to ameliorate the serious problem of overrepresentation of Aboriginal people in prisons and to encourage sentencing judges to have recourse to a restorative approach to sentencing. And this is a duty, right? Now, court held in this case that the sentencing judge did in fact err in a number of ways in limiting the application to the circumstances of Aboriginal offenders living in rural areas or on reserve. Moreover, he does not appear to have considered the systemic or background factors which may have influenced the accused to engage in criminal conduct or the possibly distinct conception of sentencing held by the accused. You can see here the incorporation of subjective factors in sentencing. That's not entirely shocking. In any event, the court held, no harm done because the accused was granted, subject to certain conditions, day parole after she had served 6 months in a correctional center. And about a year ago it's a year from 1999, granted full parole with the same conditions. So again, no harm done. Okay, so why is this important? Okay. Is it working? How about that? So let's look at a few Sorry to harm your eyes. Let's look at paragraph 58 of the decision. I just like this one because section 52, actually, Canada is a world leader in many fields, particularly in the areas of progressive social policy and human rights. Okay, now let's go down to section 58. If over-reliance upon incarceration is a problem with the general population, it is a much greater concern in the sentencing of Aboriginal Canadians. In the mid-1990s, Aboriginal people were about 2% of the population of Canada, yet they made up 10% of the penitentiary population in Manitoba and Saskatchewan. Aboriginal people constituted something between 6 and 7% of the population, yet in Manitoba they represented 46% of the provincial admissions, and in Saskatchewan, 60%, right? So obviously, this was a serious problem. And if we look down at paragraph 65, now the Supreme Court recognizes, okay, and what I was going to say is, what this kind of legislation is, it's a sausage machine type of approach. If we tinker with the system, something like sentencing, we will get justice. So even the Supreme Court recognized, that's just a factor. Paragraph 65, it is clear that sentencing innovation by itself cannot remove the causes of Aboriginal offending and the greater problem of Aboriginal alienation from the criminal justice system. The unbalanced ratio of imprisonment for Aboriginal offenders flows from a number of sources, including poverty, substance abuse, lack of education, and the lack of employment opportunities. So stop there. It's recognized there may be other sources, and we don't know the degree to which these individually influence things. And we certainly know that even the court recognized that sentencing alone was not going to solve the problem. But where are we today? And what's interesting, the notice I got, this is what it said. Since 1999, the overrepresentation of Indigenous peoples in the criminal justice system has only increased. According to statistics from the Office of the Correctional Investigator, the overall Indigenous inmate population has increased some 18% in recent years, while the non-Indigenous population has declined by more than 28%. Indigenous people are overrepresented in Canadian prisons by a factor of well over 6 to 1. So by any standard, the legislation's a failure. But in Canada, the response to failure is more of the same, because apparently what we're going to keep doing is just try to make the legislation and its interpretation more effective and try to figure out, well, is there any other tinkering we can do? So it doesn't work. Let's just keep doing the same things over again, which brings us to the next topic that I want to address, which is something you'll all be familiar with. In Canada, despite what may be going on in the rest of the world, 20% of Canadians, due to their medical status, remain on no-fly lists, which is a big deal in Canada. It's a big place. And here's a little example of what I mean. Let's have a look. What does it mean to not be able to get on a plane in Canada? Okay, if you're in British Columbia and you have a relative dying in Nova Scotia, this isn't uncommon in Canada. If you have a sister there, you want to be there at the birth of her child, you're going to have to walk or drive 4,583 kilometers to get there because you cannot get on a plane. So this is a very big deal. But fortunately, in Canada, we have a parliament. We have an opposition that will ask questions in question period. That's what we call it. And of course, the government will, in good faith, do its best to answer the questions. And thank goodness, because this is why the parliamentary system works.
It's the UK. These are just a few of the countries that have dropped all their mandates. However, this government, without any evidence, is continuing to bar Canadians from getting on airplanes to visit the loved ones they so want to see. Yep. They're spending $30 million to prevent Canadians from getting on airplanes. On what day will the minister allow people to fly and end the mandates?
You're here.
The Honourable Minister of Transport.
Speaker, I want to thank my colleagues for reminding Canadians of how many countries have put together a mandate to protect the health and safety of travellers, of those who work in the travelling sector. Mr. Speaker, everything we've done so far is intended to protect the health of Canadians. And we've always been guided by the advice that we receive from our experts.
Whoa, that word, experts. And did you notice what the question was? And do you know the answer was totally disingenuous, suggesting that, in fact, the policy of the Canadian government is the policy of everyone else in the whole world, because that's what the experts say. That's our parliament in action. Not a really great demonstration of what we might call open debate. At any rate, that's where we are. Now, there's one other topic I want to look at real quick, and it's kind of far afield, but it came up a while ago, and I was going to comment on it. I never got a chance, so I want to do it now. It's something you might have seen on the internet, so I'm going to play it.
Vaccin, vous autres?
Oui, tous les deux, on a une seule dose.
Ah oui? Puis est-ce que vous êtes d'accord, vous autres, avec la vaccination obligatoire?
Oui.
Oui?
Oh.
Ah oui, hein?
Wow. On dirait que je les ai drillés, Julie.
Oui. Puis qu'est-ce qu'on devrait faire avec les gens qui ne veulent pas se faire vacciner?
On devrait appeler la police.
Ouh!
Oui.
Oui. Oui!
S'ils n'ont pas leur vaccin, ça peut mettre beaucoup de personnes en danger. Fait que comme le gouvernement est en train de faire en ce moment, il faut leur couper petite chose à petite jusqu'à temps qu'ils se tannent puis qu'ils se fassent vacciner.
En tout cas, on a des futurs politiciens à côté de nous.
That is a comforting thought that this young lady is going to be a future politician in this country. May the Lord help us. At any rate, when I saw this the first time, the first thing that popped in my head is, where are the men? Where are Quebec men? Where are the fathers of these kids to stop this? And then I got thinking, well, how did it get to this point where this could be aired? And the guy with the man bun in the back cheering them on. How did this happen? I mean, Quebec was discovered by Jacques Cartier in 1534 and planted the cross on the Gaspé Peninsula and took possession in the name of the King of France. That's a pretty brave guy. You have Samuel de Champlain founding Quebec City in 1608. It was a pretty rough time to be walking around Quebec founding cities. He would have been, and that small pocket of Frenchmen there would have been a tribe among tribes, quite apart from what you may have heard. And then we have the explorers, guys like Etienne Brulé, who explored the land, traded, coureurs de bois, voyageurs, and the like. Pretty tough, brave guys. I don't think they would have put up with that nonsense. So where the heck are they? Etienne Brulé, in fact, when the English would periodically toss the French out, would decline to go and say, "Lad, stay here." Even though he was eventually butchered by the Iroquois, but these are brave guys. So what happened? And even by World War II, Quebec was run by what's called the Union Nationale under Maurice Duplessis. This was a party representing authoritarian Catholic Quebec, a very different place than it is today. So you can see how fast things changed. Duplessis, for example, championed rural areas, provincial rights, and anti-communism, and opposed the trade unions, modernizers, and intellectuals. And from our vantage point, that looks pretty good. Okay, it was a traditional Catholic morality that was advocated and supported, and church doctrine defined many aspects of daily life, highlighting traditionalism. For example, most schools and hospitals were church-controlled. Births outside marriage were rare. Abortion was illegal, and divorce was not fully legalized in Quebec until 1968. Well, what happened? What happened was what we call the Quiet Revolution, a essentially non-violent revolution in which Quebec was rapidly transformed after the election of the Liberals in the 1960s into a secular, materialistic, Marxist state. Okay, and again, to this day, Quiet Revolution is seen as a wonderful thing. And it's great always to get modern, but then take a look at the outcome. I'll read you some statistics, and maybe this might explain why there's no men. And I do this with all due respect to the many great guys from Quebec. I'm using this in part rhetorically, but what has happened to this country, to this nation, to the province state of Quebec? Let's read you a few things. Cohabitation rates among young couples rose as the institution of marriage gradually lost its obligatory status. Births outside of marriage began to rise from 3.7% in 1961 to 10% in 1976, then 22% in 1984. As of 2015, 62.9% of births were outside of marriage. So where are the guys? Well, for one thing, many of them would probably be snowboarding, and in the rest of their life, they may never get married. And if they do get married or go common law, they're most likely to have maybe at most one kid, and that's just not going to do it. And evidently, they're also absent from at many other points in their children's lives, as we just saw. So that's plenty for today, and we'll talk soon.